Order number 4, sir. In the name of the Honorable Leader of the Senate, to move the second reading of the Employment Prevention of Discrimination Bill 2020.
Mr. President, as I rise to introduce the Employment Prevention of Discrimination Bill, which was designed to protect persons from discrimination related to their employment, it could not have come at a more opportune moment following what just happened in this honorable chamber. Mr. President, discrimination, it goes deeper than actions. It goes deeper than policies or rules or privilege, sir. Discrimination is a symptom only of attitudes, of beliefs, of people's values, about how they value other people and about how they treat other people. It is unfortunate, sir, that we are at a time where people's attitudes, their beliefs, and the way in which we value people and treat people is not always aligned with the highest ideals of our own humanity. As I rise to introduce this bill, sir, I trust that we will all, those of us here in this chamber and those of us who may be watching elsewhere, will assume the position, try on the perspective of the victim. We have seen someone victimized today in unbelievable ways in this honorable chamber. Now, this particular bill, the Employment Prevention of Discrimination Bill, it speaks to various forms of discrimination. It speaks to discriminating against individuals because of their race, because of their origin, where they come from, because of their political opinion, because of their color, their creed, their sex, their sexual orientation, sir, their domestic partnership status, whether or not they're married or they're living together as partners, or it speaks about not discriminating against persons because of their trade union affiliation, their pregnancy, whether they're pregnant or not, whether they have to take maternity leave, whether what is their social status. About discriminating, sir, against people because of their medical condition, because of a disability, because of their age, or because of their physical features, sir. All of these are addressed in this bill as possible areas where we should not indeed be exercising discrimination. And as we talk about discrimination, sir, there is a very long meaning in part 2, sir, that is given of discrimination, but I will read only part 3(1)(a) with your permission, sir, of this bill. It says, for the purposes of this act, a person discriminates against another person where the person, and there are some words in between, makes a distinction, creates an exclusion, or shows a preference, the intent or effect of which is to create a disadvantage, restriction, or detriment. The definition goes on, sir. But I think if we continue to try on the perspective of a victim, we can understand, sir, why this bill is so timely in Barbados. Because there are certain entrenched values, there are the ways in which we have done things that have become the status quo. The majority has determined what the standards and the norms will be, and that is all fine and good, provided that we do so in a way that is fair, in a way that does not exclude others who have the same rights and ought to have the same rights and privileges of others to be a part of the workplace. This bill, sir, speaks of making accommodations in situations where you have persons who might otherwise be discriminated against, rather than discriminate against them, see how we might be able to accommodate them so that they may be included in a way that is fair. We talk about flexible work arrangements being available to persons who may very well need them. We talk about modifying furniture or equipment. We have many persons with disability who can do the job, who are willing to do the job, who are fit for the job, but it may simply mean that certain accommodations may be needed in the workplace in order to enable them to do the job. It also speaks of alternative work employment, sir, and being able to say, well, if for some reason a person could not do this particular job and something may have happened that has caused them no longer to be able to do so, that you are able then to provide them with alternatives. I think what this is saying, Mr. President, is that when it comes to who needs, in fact, to show honor in the workplace is not just the employee in terms of them being the ones who are committed, the ones who are devoted, the ones who have to make sure they're there on time, the ones who have to make sure they're making all the accommodations for the employer. It has to be a two-way street, Mr. President. It is saying that the employer equally has to be able to ensure that the environment is created, that the employer too is committed, that the employer too is showing a level of tolerance and a level beyond tolerance, but not just giving people a sense that, yes, you're included because I am required to do so, but that you have a sense of belonging that goes deeper than simply being said, yes, you can be here too. Mr. President, this particular bill speaks about testing, interestingly enough, with regards, and it speaks, sir, about no testing of potential employees for medical conditions unless it's related to occupational qualification. It speaks in this situation, in this particular bill, Mr. President, for example, well, you understand that a pilot who might need to fly a plane might need to get the testing for their eyes, for their eyesight. But we cannot go around testing that pilot for other things that do not relate to their occupational qualification or to the safety of others necessarily. Sir, this bill also speaks about enforcement. It speaks about the fact that this bill would be enforced through the Chief Labor Officer, and that complaints made against an employer, that they can be made against an employer, as well as a fellow employee. It speaks about a process, Mr. President, whereby matters concerning discrimination must first be addressed at the level of the workplace, and where they have exhausted their options, then it is advanced to the Chief Labor Officer, where there is no resolution at that level. The Chief Labor Officer, sir, is expected to exercise their very best efforts to settle the matter through some conciliatory process. A complaint, however, may be referred to the tribunal through the Chief Labor Officer, where a settlement is not achieved. And one, Mr. President, in this bill says that you cannot take forever to resolve these matters. It speaks about the fact that the Chief Labor Officer may refer the complaint to the tribunal where settlement is not achieved within 42 days of the presentation of the complaint. And that complaint, sir, there are many people who feel hard, find it difficult to forward a complaint because they believe they might be victimized. And so those complaints, Mr. President, may be filed by a single person. They may be filed by a third party, some person else who is filing, who has witnessed or seen or by a trade union, or even by a representative group on behalf of the victim. And so there are options here where the victim does not have to be left alone, and where the victim does not necessarily have to feel as if they have nowhere else to turn, because they may do it on their own, or they may seek the support of others, or others may seek to step in and provide the support for this person who is the victim of discrimination. Mr. President, this bill also speaks and provides some direction and some guidelines, I would say, with regards to the actions that a tribunal can take. It says that where a complaint is made to the tribunal and that complaint is upheld, that there are several different courses of actions that can be taken. Among them, that the offending party may very well have to pay some kind of compensation to the victim, or they may face prison. And for different types of offenses, the penalties are different, as one would certainly expect. And among a number of the different offenses that people can certainly be cited for, employers or entities may be cited for, relates to, for example, failure to maintain confidentiality of medical records, where that employee is feeling victimized. And I'm just giving you some examples, sir, of some of the areas in which there can be certain penalties applied to pay compensation, or where prison may very well be an option. And within the bill, sir, I will not go through them now. It specifies what some of those options are at this particular time. In addition, sir, the tribunal may very well insist and order that the offending party, as I said, pay compensation, implement certain policies or measures, or stop certain policies and measures, and indeed that they should also report to the tribunal on progress. So it is not a blind situation where there may be an order and then people are left to do as they like. It is a situation where there is an opportunity for them to continue to show that they're being accountable and they are indeed following whatever is the judgment and the order of the tribunal. Mr. President, the effective date. People say, well, when will this come into effect, sir? It will come into effect by proclamation, sir. Understand, too, that government and workplaces will need to get themselves ready. They will need to put the requisite administrative structures in place as detailed in the legislation. And they will also have to, and among some of those is that they will have to maintain a confidential register that is done by the Chief Labor Officer of those complaints. And the organizations must have workplace anti-discrimination policies in place. You will note, sir, that the guidelines for the content of such policies are outlined in the first schedule to this bill. Mr. President, this signals the direction in which we wish to move the rights of our labor force, the way in which we choose to respect, be inclusive, and ensure that diversity is represented and respected, that people believe that they are valued, know that they are valued, the way in which people are treated within the workplace, and basically the way in which we show our humanity as a country as it relates to how we treat to persons in the workplace. And it is with these few words, sir, that I beg to move that this bill be read a second time.
Recognize Romel Springer, Senator Romel Springer. Thank you, Mr. President. Mr. President, I rise this afternoon to lend my voice in support of this Employment Prevention of Discrimination Bill 2020, which not only seeks to protect both current employees and prospective employees from unfair discrimination in relation to job creation and recruitment, but also seeks to prevent discrimination as it relates to promotion, transfer, and training, thereby creating a work environment that promotes a sense of equality, inclusiveness, and fairness. Additionally, the legislation provides for reasonable accommodation measures to be put in place by the employer that takes into account the employee's creed, sex, sexual orientation, pregnancy, maternity, family responsibility, medical condition, disability, and physical features. Mr. President, this bill is comprehensive in its treatment of discrimination, but of the 19 or so items identified in this bill this afternoon, I guess, in the interest of time, I will focus on perhaps only 3 or 4 and explain to this honorable chamber why this bill is important, extremely important and relevant at this time. Mr. President, equality and freedom from discrimination are outlined as basic human rights by the Universal Declaration of Human Rights. However, racial discrimination has been a feature of the Caribbean experience since the first arrival of Europeans to this region in the 15th century and the subsequent arrival of African enslaved persons in the 17th century. Since that period, Mr. President, a system of racial oppression has been upheld by those dominant groups within Barbadian society, and we as the descendants of those African captives have been engaged in a long-lasting battle against racial discrimination that has today manifested itself in some form of systemic racism or systemic discrimination within a modern Barbadian context. Now, notwithstanding the current laws and the many amendments that have been made to ameliorate or to ease the effects of discrimination, it saddens me to report that racial discrimination still remains a feature of the Barbadian socio-economic landscape to this very day, Mr. President. Now, there are some among us who believe that there's no such thing as racial discrimination in Barbados. And they will have you believe that what we experience here can be better described as some form of elitism or classism. But there's evidence to support the view that what really exists in Barbados can be described, and these are the words of Barbadian historians, can be described as crypto-racism, which in their words is even more insidious than the overt racism that we have seen in other jurisdictions, Mr. President. The reason being that this crypto-racism has managed to camouflage itself by appearing to be traditional forms of recreation, traditional forms of leisure time, traditional forms of commercial activity. So you may not necessarily see it on the surface, but just scratch below the surface and it's there. And nowhere is this more evident, Mr. President, than in the workplace. How else would you explain a person laboring diligently in an organization for years, Mr. President, for years, and being overlooked for promotion, all the while being superseded by persons of a lighter hue, with significantly less years of experience and qualifications? How would you describe, Mr. President, the disparity in salary of persons of a similar grade, similar job description, where one person just happened to be of a different race? How will you describe, Mr. President, the language that's directed and the manner in which some persons are treated at the hands of their employer, who just happen to be of a different race, Mr. President? How do you describe it? These aforementioned are but some of the experiences that many a person in Barbados, many a person has encountered. But yet some would have us believe that racial discrimination does not exist in this country. This bill, Mr. President, in a small way, seeks to remedy this historical wrong. I refer to, I believe it's clause 24, subsection 1. Just let me find, I highlighted it here. Where it speaks to an employee, if they experience some form of discrimination in the workplace by another member of staff, they have it now allows them to write a complaint within the 3 months period. To complain, to put in writing to write complain about the experience, and the employer is now compelled by law to investigate that complaint. What might have occurred in the past is that the employer might have dismissed the employee, that person, either dismiss them by ignoring them, or maybe go as far as to dismiss them by way of termination. But now, this law, under this law, that employer now is now compelled to investigate. And if it is found, Mr. President, that discrimination occurred within the workplace, then the employer is obligated to act against the perpetrator, bring disciplinary action against the perpetrator. Then by chance, the perpetrator happens to be the employer. The employer still has the right to put in writing a complaint, and perhaps, if nothing is done about it, may go as far as the Employment Rights Tribunal to have their complaint heard at that level. So this particular provision here, this particular bill, Mr. President, is a step towards bringing that level of equality within the workplace, fairness within the workplace, Mr. President. So persons who experience it, and believe me, there are persons who can tell you about the indignity of being treated in that manner because of their race, and how it makes a person feel. And now they have recourse. I want to turn my attention to another form of discrimination, which is also very prevalent in Barbados. This is sex discrimination. Discrimination based on your sex or your gender. And this involves treating someone unfavorably because of their sex, whether they are applying for a job or whether they are already employed. Mr. President, the issue of sex discrimination still lingers within our society. Although women have proven consistently and conclusively that they possess the ability to perform with the same proficiency and achieve the same successes as men, the belief that they are weak have often denied them the opportunity to function in certain roles within organizations, and it has curtailed their occupational development. Now, let me hasten to add that although sex discrimination is predominantly an issue that impacts women, there are some men who are sometimes victims of sex discrimination as well. So I just want to make that point for clarity. Now, the fact that there are bureaucracies and corporations where men are privileged in ways that women are not is one reflection of patriarchy within our society. And one way in which patriarchy is perpetrated is through the glass ceiling effect that still persists in work environments within this country, Mr. President. And the practice exists even though we can cite Barbadian women that, and their regional counterparts, whose accomplishments are irrefutable evidence of the absolute necessity of shattering these obtrusive glass ceilings. Oh dear. Dame Ermi Bourne, who was the first black woman elected to the lower house of Parliament, and our very own Mia Amor Motley, the country's first female prime minister, are but two good examples of women who shattered that invisible impediment that, because of our patriarchal society, has placed barriers in the upward mobility of women in the workplace. Mr. President, as a country, we must strive for gender parity. But this can only be accomplished through conscious diversity management via policy, which is what this particular bill, I believe, seeks to encourage. Mr. President, this is a prevention of discrimination bill. But I anticipate, Mr. President, that the time will come when, as a country, we will consider diversity management as a means of reinforcing equality and inclusiveness within the workplace. Now, Barbados' economy is small, it is open, and it's vulnerable. Since 2008, we have faced certain fiscal challenges that have had negative impacts on the livelihood of many persons, and it's impacted their standard of living. But according to statistics from the United Nations Economic Commission for Latin America and the Caribbean, women have been more severely impacted than men, and this, amongst other things, has resulted in underemployment and the devalorization of work by women, the rendering of women to menial jobs, to jobs in the service industry, cleaning and washing and so on and so forth. And this bill, Mr. President, ensures that in a modern Barbados workplace, everyone, including women, are paid their value and their worth based on their qualifications. Mr. President, the state has a moral and social responsibility to amend past wrongs done to specified disadvantaged groups in society. And in the case of this particular piece of legislation, we are trying to reconceptualize some of the norms that guide our society to provide what can be described as a more level playing field for women, Mr. President. Simply put, that's what we're trying to do. Create that level of parity, that fairness, that inclusiveness for our female counterparts in this country. That there will never be a case of that level of discrimination that we would have seen in the past. Now, I will briefly touch on discrimination based on disabilities, because that is another one that I think that needs a champion in this country. According to the ILO, there are approximately 470 million persons worldwide of working age that have a disability. While many are successfully employed and are able to integrate into society, as a group, persons with disabilities often face disproportionate poverty and unemployment. And in Barbados, there has been a timid approach by organizations in relation to employing persons with disabilities. And this is unfortunate because we know that persons with disabilities are some of the most vulnerable persons in Barbados or in our society, and due consideration must be given to ensure inclusivity as it relates to such persons. Internationally, workplaces are realizing the many advantages of hiring and promoting persons with disabilities and creating inclusive workplaces. And this is because disabled people not only have a valuable contribution to make to the national economy, but their employment also reduce the strain on the national purse, on disability benefits and such like. But what this bill does, more important than anything else, is that those persons who are currently employed, those disabled persons who are currently employed, but who are facing discrimination, under this particular bill, they have some form of recourse. As mentioned by the Honourable Senator when she led off the bill, employees now have to take deliberate steps where feasible to address the particular workplace needs that any worker with a disability might face. And that brings me to clause 7, I believe it is, where it speaks to the various steps that one might take as an employer, the various adjustments that can be made to accommodate persons with disability. I would not mention all. Some were mentioned by the Honourable Senator when she led off the bill, but I will identify just a few. It includes assigning the employee to a different place of work, acquiring or modifying equipment for the use of the employee. You may even make some adjustments to the premises in terms of installing ramps and what have you, and lifts, so that the person could be accommodated in different spaces. And those are just some. In the interest of time, I'm going to not mention anymore, but you can see where I'm going with this, where you retrofit the space so that persons can operate within. Mr. President, at the heart of this particular piece of legislation which calls for inclusion of persons with various disabilities is social justice. This act provides legislation that provides protection for persons with disability. And what it also does is that it limits employers from refusing to hire suitably qualified and competent persons with a disability. If a person is suitable for a job, that person cannot be refused employment simply on the grounds that they have a disability. And I believe that is a step in the right direction, where we as a country should be going. So as I conclude, I just want to note that this bill is just a start as we continue working towards a more inclusive and equitable Barbadian society. We must accept that discrimination not only deprives competent employees of a chance to showcase their capabilities, but also restricts their earning potential, which then impacts their standard of living. It is the commitment of this government to enact the necessary legislation to provide the framework to regulate work conditions so that all employees are afforded the opportunity to work in a discrimination-free environment. This transformative piece of legislation allows Barbados to move away from traditional workplace biases and to realize the potential of all employees and to move towards a culture of diversity management where the contribution and the different perspectives and abilities of every single person in the workplace is valued. With those few words, Mr. President, I'm obliged.
Senator Moore.
Thank you, Deputy President. This evening, I am heartened that we can be here to discuss the piece of legislation before us that speaks to or speaks against discrimination in employment. As one who studied in Canada some 19 years or so ago, and who was a student of diversity management back then, Canada being very forward and ahead of the game in treating to such issues, I think that it is a long time in coming for us. A long time in coming when we speak of legislation. Although we ratified the ILO Convention 111, that speaks against discrimination in employment and occupation since before I was born. In 1974, it came into force in Barbados, a convention that was adopted at the ILO in 1958. And that it has took us 46 years to give the ratification teeth is shocking, is unfortunate, but nonetheless, here we are. Because although as a country, as a member state of the ILO, we would ratify conventions, ratifications only really make sense if governments, the member states of the ILO, bring them into law. But Deputy President, why I stand here in support, and I must add that this particular piece of legislation relates to discrimination in employment, which is one of the 8 core labor standards of the International Labor Organization, and Barbados has ratified all of them. But we are now bringing this into law. While I'm happy that we are moving towards treating to this within our national legislation. And while, of course, that it has more meaning having it in our legislation rather than a simple ratification, I wonder if it was necessary to introduce it in the form. Having waited so long, I wonder if it was necessary to introduce it in the form that is presented before us as a separate piece of legislation, rather than treating to it within the context of our Employment Rights Act. The Employment Rights Act, which was proclaimed in 2012, the Employment Rights Act, which has so many deficits that have been outlined, and which would have given some of us at least greater comfort that the government was moving seriously and sensibly and more systematically towards addressing a number of the gaps that present themselves when we treat to labor rights and workers' rights. So it's a good thing, but to set it apart without treating to it within the context of the whole, where we recognize so many other rights being infringed on a daily basis, is somewhat concerning. When we spoke to the Minister of Labor and Social Partnership Relations early in his tenure as Minister of Labor and Social Partnership Relations, the concern was voiced from workers and their representatives that we needed urgent fixes to the employment rights legislation. Fixes that are still needed over 2 years later. But I speak this evening specifically of discrimination at work. Discrimination at work, according to the International Labour Organization, is defined as any distinction, exclusion, or preference which has the effect of nullifying or impairing equality of opportunity of or treatment in employment or occupation. And it's important to understand the definition, and yes, indeed, the legislation treats within this broad definition that is offered by the International Labour Organization, which I think is important for pointing us in a good direction. It speaks then, Deputy President, to the fact that whether you're an employer, an employee, or a job seeker, understanding employee rights is crucial to ensuring a healthy workplace. So it includes such things as rights to be free from discrimination and harassment of all types, right to a safe workplace, free of dangerous conditions, toxic substances, and other potential safety hazards. It also speaks to the right to feelings of safety. And that's why in our own safety and health at work legislation, there is a section that clearly outlines that where a worker perceives himself or herself to be in imminent danger, that worker has the right to remove themselves from the condition that presents to them and causes them to feel that they're in imminent danger. And maybe I should stick a pin there, because even in the context of what we saw here this afternoon, I don't think that it is fair for any of the honorable senators in this chamber to get on a high horse and behave as if senators who remove themselves from this chamber, who may perceive themselves as we have in our legislation to be in imminent danger, I don't think it is fair for any of us to rail and make suggestions regarding their motives, because the very legislation that we are speaking about here this evening, that is before this chamber, is a legislation that suggests where a person makes a complaint or where a person supports another in testifying against a particular kind of behavior, that that person should not be victimized, that that person should not be harassed, that that person should not be harangued. And I just want to suggest to this honorable chamber that two wrongs, even if we consider something a wrong, don't make a right. I leave that there. Discrimination also speaks, or maybe moving along very smoothly, to the right to be free from retaliation for filing a claim or complaint against an employer. And sometimes this is called whistleblower rights. Right to fair wages for work performed. Rights afforded to job applicants. And job applicants also have certain rights, even as we said before, being hired, so that they must not be discriminated against because of their age, their gender, their race, their height, where they live, their religion, etc., as outlined in the legislation before us. But, Deputy President, although this piece of legislation is addressing this in a very holistic way, perhaps for our own reflection, we may wish to ask ourselves the question, why, if some of this protection is already available, workers still feel that they need to be protected? Why is it that if we have a Trade Union Act that already speaks against discrimination on the basis of one's affiliation or desire to be a member of a trade union body, why is it that we still find it necessary to reinforce it in this legislation? Why is it that if there is a constitutional approach to a fair day's pay for a fair day of work, that workers still have to be fighting for rights that are already entrenched? Why is it that if already we have legislation that speaks against discrimination on the basis of disability, why is it that today in Barbados we still have to be speaking to these things? And it's simple. If we're going to have pieces of legislation, and if we are not going to enforce the legislation, or if we are not going to develop or improve on the pieces of legislation, and if we will prefer to even put other pieces in place and we don't do the same things to them, we will be here. Perhaps we won't be here, but others will be here later making some of these same pleas. What am I saying? Where am I going? I'm saying that anti-discriminatory legislation is indeed necessary, but more important than putting a piece of legislation in place, or maybe putting in place another piece of legislation so that we are comfortable within ourselves that it can be attributed to us, that we should be making swifter and more dedicated efforts towards enforcing the rights that are already provisioned for. Otherwise, there are so many workers out there that hearing the debate in another place and following the debate here, that can be just another piece of legislation. That's a feeling out there, unless we demonstrate that with what we have, we are making it meaningful to people. You know, I was in a conversation recently with a colleague of mine, and we both found it interesting that although we have several pieces of legislation that may be described as beautiful pieces of social engineering in Barbados that make provision for fines and penalties ever so slight, that we can recall or find a single place where anybody in Barbados was fined, was imprisoned, was charged for breach of labor legislation. Of course, at the Labor Department, they hear a lot of cases. But we're talking about the legislation having meaningful application elsewhere to people. So as I said, Barbados has ratified the C-111 against discrimination in employment, Convention 111, that is against discrimination in employment and occupation. But it is before us now. I heard the Honourable Senator that spoke before me made mention of the need to have a conscious diversity management policy. And I support him, and I support that view 100%. But I'd like to suggest that it's not simply enough to have it, but it is more important to create the conditions in which the performance of people or the barriers to people's performance can be minimized. I also think that in having a national diversity conscience, that it is important for us not to bring pieces of legislation or not to throw bits and pieces into legislation that we are seeking to have enacted without addressing the broader issue of diversity policy in Barbados. And it's against that particular backdrop, or with that comment in mind, that I raised the concern of the definition. One of the definitions that has been submitted for domestic partner. As I read it, I question, what is it? And not because I don't see the definition written into the draft, and not because I'm unaware for the meaning it has in other places, but within our context, what is it? More importantly, what is it trying to achieve? And if my understanding is that we are seeking to broaden diversity management policy so that we address the issue of discrimination in all its forms, then, Deputy President, isn't there a need for a wider debate? We had it coming up when we spoke about the welcome stamp a couple weeks ago. Deputy President, I hold a privileged position on the governing body of the International Labour Organization. Whenever I speak for workers nationally or regionally or internationally, I speak for all workers, and I speak out against discrimination of all workers. The ILO has a tendency to say all workers including, and they give a whole laundry list. I like to leave it at all workers. So my issue with the definition of a domestic partner is not against any view that there are certain categories of people that need to be given attention. But it is to signal to us that if we want to address different lifestyles, or if we want to broaden the net on diversity, that it seems a little hoodwinking or backhanded to be introducing it into legislation without having the national discussions. Because what we are likely to do is to introduce pieces of legislation without allowing for the appropriate national sensitization on the issues. And what is likely to result is that we will have it, but it still won't really make a difference to the people who we want it to make a difference for. So, national, domestic partner has a definition in the proposed piece of legislation as domestic partnership, has a definition as a relationship between two persons, each at least 18 years of age, who live together on a genuine domestic basis, but does not include a relationship between a married couple. Although I will see a marriage as a genuine domestic relationship, because you live in a house, you live in a domestic situation, you're having sex, presumably. You're sharing a number of things, financial resources included, again, presumably. So we're making the distinction between a domestic partnership and a marriage. So we know we ain't talking about, but then again, do we know that we're not talking about married couple, or what is a married couple in this definition? We don't know anymore, because when you create distinctions for things that we understand to have meaning in our culture and in our upbringing and in our socialization, and then you're saying something different, then it raises questions in our heads. Then it speaks not a married couple, or not a relationship where one of the person provides the other with domestic support or personal care, or both, for a fee or reward. And domestic partners shall be construed accordingly. Domestic partner should be construed accordingly. And then it says domestic partnership status means the state of being a domestic partner construed according to the domestic partnership definition, or the domestic partner or the former domestic partner of a particular individual. What is it that we are going after? Who is it that we are trying to bring non-discriminatory policy against? Let us be upfront with it. Let us have a national discussion on it. Let us have a referendum if that is required and if that was committed, as I believe it was. So the definitions that we see coming up appear questionable, not because of what they potentially are trying to get at, but the way in which we seem to be introducing them. I spoke about the trade union affiliation. No problem mentioning it here again for reinforcement at 3(2)(d). But in the Trade Union Act, it provides for enforcement of a sum not more than $1,000 if you infringe that, or imprisonment for 6 months. When I had this draft legislation before me, I read it excitedly because I was there like, yes, maybe now we can be able to move in And in the same way, in integrity legislation, we're seeing figures like 50,000 and so on. We can get some bigger numbers coming here that would deter people, possibly, from discriminating on the basis of trade union affiliation. But Deputy President, I was shocked because in the enforcement of this legislation, I didn't see a fine for that. What you see a fine for is $20,000 or 2 years, I believe, if a person complains or if a person testifies of some discriminatory act being meted out on an individual, and then an employer turns around and victimizes the complainant or the person testifying. But the piece of legislation before us doesn't say anything in terms of enforcement of what will happen if some person discriminates on the basis of height, religion, sex, age, whatever. So that's another thing that I regarded in looking at this legislation as a gap. Then in section 8, we speak about genuine occupational qualification, not unique to Barbados and not unique in terms of seeing it in different pieces of discrimination legislation, but problematic nonetheless, because what is a genuine occupational qualification? What makes height genuine? What makes being a female genuine? And I know that the legislation does attempt to bullet out some things, but there's always the question, these kinds of concepts that are so open always raise the question of interpretation and burden of proof and all kinds of things. So to me, we say a lot of things and we put things in place, but in terms of it having real meaning, these kinds of terms broaden it so that the legislation is protecting, but yet it's not in some respects. Burden of proof, Deputy President, can be a significant hurdle to obtaining a just and fair result in any case of alleged discrimination. Burden of proof, and similarly time. Because if a person perceives that he or she has been discriminated against in terms of seeking to access employment, and we have a provision and a process that takes at least 3 months, then the job, for instance, if it's a recruitment, discrimination in recruitment, a job can be filled by the time a person has access to a hearing. Then what? The job is already filled. What sense it makes? And the next time something like that happens, the job will be filled. So we have, if we are looking to implement and engineer modern pieces of legislation that reflect the times we are in and would give people comfort that we are moving in a direction that is more than words on paper, that is so convoluted that the average Joe can understand. I think, therefore, it is time for us to not look to fit into the mode of other legislators that implemented things since 40 years ago, but that we should be moving past where we ought to have been in 1974 when we ratified this particular convention. Similar thing can be said for an employer proving unjustifiable hardship. My next comment relates to the clause on religion. It speaks specifically to religious dress. A person should not be discriminated against on the basis of their religious dress. Again, I felt that the legislation should be going a bit further and speaking about discrimination on the basis of religion, full stop, and not just attire. Very frequently in the employment relationship, complaints arise as to why certain people get privileges not to work on their day of worship, and other people, for instance, don't get those privileges. Why there are some who will not be rostered on a Saturday, but why there are others who worship on a Sunday and who will be rostered. That's discrimination. That is discrimination. And the Labor Department has seen a number of these cases, and I'm surprised that the legislation under the caption, under the clause on religion, restricts it only to dress and not broadens it to the realities and the complaints that we see often enough in the employment relationship. Then there's a section 18 before us that I really don't know what it means. It seems to stand out like a sore thumb. The clause 18 under the heading employment other than in connection with a business is simply one line. This act does not apply where the employment is not connected with a business of the employer. What was the business of the employer? Because we don't have any definition. Is it that we mean if the employer is not in a contract relationship, if they're not family, if they're not friends? What do we mean by not connected with a business of the employer, or if the employer doesn't have a business? Because depends on which of these we mean. Depending on which of these we mean, then the response or the analysis can be different. In employment right now, we see a trend, and I've raised it before in this honorable chamber, where employers are avoiding the formal types of relationship, employment relationship that is, and seeking to engage workers on the basis of a contract. Because if you're on a contract, I don't have, as an employer, the same obligations to you. So then, if I contract an employer who is discriminating in any form, does that make me, the contractor, less guilty than the contracted employer who is engaging in the practice? Is this saying that once it isn't your business, owned business, that it is okay? And that raises some concern and ambiguity. Ambiguity first and concern secondly. That's section 18. So I've already mentioned about the enforcement and so on. So, well, Deputy President, my contribution this afternoon is not to say that this discrimination or anti-discrimination legislation is wrong or is not good. I think that it is useful that we are seeking to give teeth to what has been brought into force over 40 years ago. But what I think would mean more to workers and their representatives, certainly, who have to be on the ground daily dealing with these things, is if it makes more practical sense. And if we've waited so long to do something, my suggestion is that we do it right. It has some consequential changes for the Employment Rights Act, which I find personally to be disappointing because what we're doing is we're tweaking with minor concerns in the act without treating to the real deep-rooted issues that we have in the act that are preventing persons from accessing their rights on a daily basis. We have a Protection of Wages Act. And in 2020, and especially in a COVID-19 situation, every week since March, workers' representatives have had to be treating to issues with employers that are taking out money, deducting people's wages without their permission. That's all right. And this brings me to the Labor Department. Because yes, we can say that the office of the chief labor officer has purview over these things, so they do over everything else that is before them, and where justice is not being meted out. So unless we strengthen the system, of meting out justice, all we can do is have another piece of legislation that people could challenge, and more delays and less access or slower access to justice. So I think that while I'm lauding it and saying that it is good, it is useful, I'm criticizing to say that more needs to be done. And if we have waited this long, and if we have before us more critical points of concern that need to be addressed, I think that we are kind of like just brushing over and brushing the surface so that we can say we've done something. But Deputy President, my criticism would be that it is not nearly enough, given the times, given where we are, and given where we need to go. Thank you.
Senator Dr. Holler.
Thank you, Mr. Deputy President. I seem to be following Senator Moore more often than not in these debates. I was really hoping for a robust debate this evening because this is such a critical bill. I'm recognizing that that may not be the case, but Mr. Deputy President, I thank you nonetheless for allowing me to make a very short contribution to the matter at hand in this piece of legislation. I'll begin, if you will permit me, with a story. We are discussing the issue of discrimination, and I think that government is making an effort in this proposed bill to address the issue of equity and equality within the workplace. And this is necessary in my view because of what we know to be innately within our very thought as human beings to discriminate. And my story goes back to 1019 B.C. I believe my colleague, Senator Springer, talked earlier about the 17th century. I'm going to go a little further back, comrade. And the story goes like this, Mr. Deputy President. There was a gentleman assigned the task of anointing a king, 1019 BC approximately. And as is human to do, he proceeded to the home of a gentleman with several sons who he was led to believe that the king would come from this home. And Mr. Deputy President, he looked at the various sons, the men were assembled before him, and as is true to form, he counted each of them and he felt that at least one of these had to have been the person selected to be this king, primarily because of how they looked. So the first son came before him, he looked the part, he had the height, he had the build, he maybe even have had the facial features, but he looked the part. And so the man felt that this had to have been the person earmarked to be this king. And would you know, Mr. Deputy President, that this gentleman went through this experience with 7 of these sons. And none of them, not one of them, despite how they looked, despite the physical features, despite how much they may have fit the bill, they were all rejected. And the one who sent this man to make the choice in the first place said to him, you see, the challenge with you people is that you look at the outward appearance, but I'm always interested in the heart. And it is against that backdrop, Mr. Deputy President, that as I looked at this bill, I recall that 3,000 years hence, we are still having the same challenge. We are still choosing based on maybe how a person looks. We heard the thesis earlier about seeking to ensure we do not discriminate against the differently able, against those based on a particular race, against persons based on the sex, etc. So 3,000 years hence, we are still making this mistake. So I am satisfied that I have said in earlier debates that the role of government is to try to correct wrongs where they occur and ensure that through the process of legislation and policy, we are able to provide an equitable environment that all persons can make a contribution to the development of the country that they're in. And so I have 3 points that I wish to suggest to us this afternoon. Why having anti-discriminatory legislation is good for our communities, is good for our businesses, is good for our people. The very first point is this: it costs when we discriminate. It costs, Mr. President, when we discriminate. And by way of supporting this with quantitative data, an advocacy group in the US suggests that discrimination costs the US economy some $64 billion per annum. Another group, a think tank in the UK, suggests that it is approximately 127 billion pounds to the UK economy per annum as a result of discrimination. But the OECD even went further, and the OECD suggested that approximately 16% of global income is lost per annum as a result of discrimination. Some $12 trillion the OECD suggested as a result of discriminatory practices. And whereas, as I did the research, the local organization here responsible for employers didn't have the quantitative data, the OECD 2016 report that I cited earlier suggested that in Latin America and the Caribbean, some $658 billion, $658 billion in Latin America and the Caribbean. Obviously, Barbados is included there. We don't have data for Barbados specifically. But that this figure per annum, Mr. President, is lost in economic activity as a result of discrimination and discriminatory practices. So there's a cost to discrimination. The legislation lists a number of areas, a number of offenses, I call them. And we don't have to go through them again. They were mentioned by other colleagues before, indicating to us that when we discriminate against persons because of their color, when we discriminate against persons because of their sex, because of their religion, if they're differently able, etc., the list is there, that there is a cost to the economy for doing so. And I believe it is because at the end of the day, Mr. President, I am of the view that each of us has been given a destiny and a purpose that we are tasked with fulfilling in the earth and in making a contribution to social development, economic development, etc. And when we are disadvantaged from so doing, the economy and our community, by extension, suffers the loss. So there's a cost to discrimination. I know, Mr. President, that the private sector here in Barbados would have expressed some concerns. I received some commentary from a key private sector agency here relative to this bill. And the fact that there are a couple of sections that they would have really liked to have had some dialogue on. And I'll mention one in particular. And if I go to the bill, I believe it is section 6 that talks about testing. Prohibition against testing for medical conditions. As I said, I know that the private sector agency here has some concerns about this. The members have been writing in and expressing concern relative to this, because the view has been made, and justifiably so, that there are occasions, Mr. President, where an employer has to conduct, facilitate, encourage even, demand some sort of testing for a medical condition because of the nature of the job. However, I want to allay the concerns of the private sector body to suggest that in looking at section 8 of the bill, I am satisfied that the exemptions here mentioned, Mr. President, can help to facilitate that environment in the workplace where the employer is enabled to carry out those medical tests. So, for example, section 8.1 speaks to, at the end of this paragraph, exclusion or preference is the existence of a genuine occupational qualification. So if there is a genuine occupational qualification, there, in my view, are grounds for medical testing. Section 3 of that same paragraph speaks to, for the purposes of this act, a qualification is a genuine occupational qualification where it is an inherent requirement of a particular position. So the point was made in discussions with a number of private sector agencies that there are times when you may have to, because of the nature of the job, test the employee for example, drug use. It may very well be a situation where if that individual is impaired, their ability to be focused and conscious and so on is impaired as a result of drug use, it can have a deleterious effect on the operations of the firm, and so the employer is justified in calling for a test in a situation like that. So I feel it is important for me to state here that while, yes, we know that discrimination costs, and the private sector entities listening on and would have an interest in this debate, because of that fact, they need now to rest assured that the exemptions clause in this piece of legislation can very well satisfy the need for any medical testing that they may deem necessary because of the nature of the job. I go further, one additional example, and I hope that when the leader of government business responds to this, that this particular point maybe can receive some sort of commentary. Section 10.2, the point is made here that there is no definite time frame to guide employers. So section 10.2 doesn't necessarily speak to a specific time frame. The section talks about use only for so long as is necessary for the attainment in the circumstances of such equality of opportunity. So the question is being asked, can a time frame be considered, or if not, is there another section that we can maybe point to that can give some support to employers in particular relative to that clause? So I think, Mr. President, that what I'm seeing thus far is enough of a piece of legislation that will allow for that equality and equity within the workplace that we desire to see. So that's my first point, that there's a cost to discrimination. My second thought, Mr. President, is there's also a cultural reality to discrimination that we must be aware of. There's a cultural reality. You know, we saw in the legislation the long list, social status and all that. You know, I looked at it and I said to myself, it would have been so good if I could have seen, somebody would say to me, but that, you may be being a little facetious, that's not going to happen. But if I could have seen school affiliation in there. So when I speak to a cultural reality, I'm speaking to that, Mr. President, because in this Barbados, culturally, we discriminate against persons because of the affiliation, because of the schools that they went to. This is something that I would like to see addressed. Now, someone once said that you cannot legislate everything, and I agree with that. You can't legislate everything. There's some things, though, that you ought to legislate. But you can also educate, Mr. President. You can educate. And you can also ensure that through the practices that you employ, the decisions that you make, the things that you do, you demonstrate the kind of equity and parity that my colleague, Senator Springer, was talking about earlier. Mr. President, in this little Barbados, 166 square miles, I am concerned that it may not be political opinion, it may not be pregnancy, it may not be marital status, it may not be family responsibility, a medical condition, but that we have institutionalized in this country the system of recruiting persons, appointing persons, promoting persons because of the school that they went to. Now that is discrimination. Mr. President, I sit on boards. I've sat on boards. I recall, by way of illustration of my point, being in board meetings or having to engage as a board member, the CEO of the organization, and hearing something like this. Mr. President, this is how the conversation would have gone on a couple of occasions. Oh, we have a vacancy. And the minister is recommending so. Because they went to so-and-so school. Mr. President, can you imagine that being said? And my rebut often is, are they competent for the job? Is the person competent for the job? Let me see the CV. Let me get some sort of resume relative to their expertise and experiences. But you cannot tell me that you are going to recommend John Brown or Jane Doe for a position because they went to your alma mater, because they sat in the classroom with you. Mr. President, these are discriminatory practices that are present in this Barbados today, in 2020. And I'm suggesting it has to stop. It has to stop. And whereas it is not listed in the first part here of the legislation, I would hope that more voices can join with mine this afternoon and speak out against this ill to the point where all persons in decision-making positions will understand that this will only change if they change it. If through our actions we change it, if it is that we start to treat the people, the recruitment of people, the promotion of people, the appointment of people, not by the school they went to, but by the competence that they have, but by the resume that they present, by the qualifications that they have. So, Mr. President, I am passionate about this point because I see it happening too often. I've seen it happen, Mr. President, too often in this country. I recall, by way of one final illustration, being in an elevator, heading to or from a meeting, can't recall, and someone in that elevator who knows me, or thought they did, asked, what year did I leave so-and-so school? Mr. President, they did not ask where he went. They just assumed that I went to that particular school. I'm not going to call the name in this chamber. But they're going to ask, what year did I leave that school? Because as far as they are concerned, there's no way that you could be where you are today. There's no way that you could have achieved what you have achieved today without having gone to that particular school. That is the kind of thinking that permeates our society. Mr. President, I'm suggesting to us this evening, it is discrimination. It is discrimination. And I speak out against it in this forum, as I have done in many others, because I believe it is wrong. And just like the story I started off with that man who went to select and anoint the future king, this is what happens to us today. So we have this as a challenge, that while I support our efforts, Mr. President, at bringing this piece of legislation to protect the workforce, this is again another challenge, another issue that employees face in this country. When they go to the interview, when they sit before the interviewer, the HR department, the HR team. Matter of fact, sometimes they don't even get there because of what the CV says. I remember at the state funeral of a former prime minister, when someone is reading the eulogy for that individual, referred to the fact that this particular individual would have looked to make sure that there was someone from this alma mater who was in the organization or on the board or part of whatever agency that he was affiliated with or had to appoint persons to. That is ludicrous. But that is what happens in this, our beloved nation. It is a part of the systemic discriminatory practices that we have in this Barbados that needs, in my view, Mr. President, to come to an end. Come to an end. So, employees experience this, Mr. President, when they go to the interview time and time again. Many actually bypass the interview process because of that reality. Now, I would have loved to see a piece of legislation that could address that. But one may say it's a bit far-fetched. But I would have loved it, because it is a perennial problem in this country that denies people who are competent, from being recognized and promoted in this little Barbados. It is wrong. It is wrong, Mr. President, and it needs to stop. So that is my second thought. And my third one, I said just 3 points, 3 quick points, and I'll be through with your indulgence, Mr. President. Three quick points I made. I said at the beginning. This is my third one. When this legislation came on the order paper, it was debated in the other place, I saw all the commentary around this, the issue of sexual orientation. We had Mr. Deputy President, the last bill that spoke to the remote work, and all of the commentary, and there's a lot of commentary, and this administration is being accused even of trying to get things through a back door. So I am going to state and place on record my perspective, as only I can. Because as far as I'm concerned, Senator Moore, the Marriage Act gives clearly the definition for marriage. As far as I'm aware, that hasn't changed. So the Marriage Act gives clearly the definition. So as far as I'm concerned, Mr. President, there is no debate here from me on this matter, because our legislation has already answered this question about what marriage is. The Marriage Act says so. The Marriage Act hasn't changed. It has not come before us for amendment. It is still the same. So that defines, Mr. President, what marriage is. But because I've seen a lot of commentary around these bills, it is important in my third thought to share this, Mr. President, with the chamber. You see, biological sex, Mr. President, is not assigned. It is not assigned. You do not and cannot decide psychologically what sex you are, Mr. President. So whenever government, any government, is going to make legislation, introduce policy, in my view, a key criteria to be considered ought to be scientific fact. It must be grounded in anthropological truth and not based on a feeling, a psychological desire. It must be based on objective truth. Now, I am aware, Mr. President, that there is the leftist view, the liberal view that is permeating our global space. And many of our small economies feel trapped, feel that some person said don't have a choice but to go along with the tide. I don't agree with that. I do not subscribe to that view. There is something called objective truth. Show me scientifically, show me anthropologically the fact about a particular thing. A mango tree cannot produce apples unless it has been altered through science. A mango tree would only produce mangoes, Mr. President. And I say that to say that an individual's genetic makeup will determine if they are male or female. And as you know, Mr. President, if you have the Y chromosome is only found in males. That's it. So you can wake up today and feel that you are whatever. That does not mean scientifically that you are that way. That is the reality of it. So we have now these influences by a minority liberal agenda seeking to indoctrinate, evangelize, if you will, the globe. A small percentage. There's a particular news link that I follow. Mr. President, in watching a recent presentation, podcast, I saw something that just startled me. the whole trans ideology seemed to be on the rise, on this growth path. Mr. President, I do not subscribe to it. Mr. President, I will not vote for it. I will have no part of it relative to institutionalizing through legislation. I am not a part of it, Mr. President. I know what the consequences of that may mean, and I'm prepared to pay those consequences. Because I'm not a part of that. Now we have, Mr. President, we've gone from transgender to now transracial. And we have the first evidence of this, a woman who would have served at the NAACP, who is a white woman, but decided that she would identify as a black woman. So we have something called transracial. Then we have transable. Transable. This is able-bodied people. One man in the UK cut off his hand because he felt that he was an amputee. He woke up and he identified with being an amputee. A woman in North Carolina threw a chemical in her eyes because she identified as being blind. Woman could see, but she identified as being blind. Then there is trans age now. Big man in his 40s called a child care agency requesting a nanny because he identified as a 6-year-old child. This is what the liberals are pushing, Mr. President, across the globe. Ridiculous ideology, ridiculous thought. And I'm saying, Mr. President, that if we do not stand for absolute truth, there is no end to where this will go or where this can go. Because a child can now decide, well, I identify as an adult so I can go and buy alcohol. I identify as an adult so I can do drugs. So people can now identify with whatever they feel like identifying with. There's no absolute truth, no scientific basis. And governments across the world are being challenged to accept this. I'm saying, Mr. President, a word to the wise is enough. Let us guard ourselves against these kinds of ideologies. Let us guard ourselves. Let us guard our value system. And not for those who may be quick to retort about religion. No, I have not mentioned religion one bit. Because what I'm speaking to, Mr. President, has nothing to do with religion. There is a higher level even. There are certain, what I call hermetic principles. They are hermetically sealed that goes beyond any religion. And so, Mr. President, as I close, that was my third point. As I close, I will conclude by saying that, yes, we want to have anti-discriminatory practices. We want to have legislation that will encourage equality and equity in the workplace. Yes, there's a cost to it, but we have to avoid the cultural reality of the school ties and seek to ensure that as we look now at this diversity management and diversity policy, that we do not go to the extreme, that we forget objective truth. Mr. President, that we don't jump on this liberal bandwagon to go against what is scientifically sound and proven, all for a minority, a small percentage of people who may keep a lot of noise and advocate loudly. But they're wrong. And all of this, the trans ideology, you know what? I keep hoping that I will see some trans sense. some trans common sense. Maybe people can wake up and identify as having sense and demonstrating that they, are people of integrity and truth and so on. Let's aim for that too. So, Mr. President, I give my support to anti-discrimination legislation in the workplace. But caution us as we go forward. Let us remember that we have to stay with absolute truth and make our decisions based on scientific fact as we go forward. I'm obliged to you, Mr. President.
Thank you. Senator Greenidge.
Thank you, Mr. President. I know it's getting a bit late, and therefore I will be brief. Mr. President, I rise to give my support to this Employment Prevention of Discrimination Bill. And I do so, sir, fully conscious of the fact that the bill itself speaks of unfair treatment in employment because of things such as sex and age and race and religion and so on. This bill, sir, is about sex orientation. It's about how people dress. It is about hairstyles. It is about how people worship. Generally speaking, sir, the bill has a lot to do with profiling. The bill, Mr. President, stems from our failure to treat all working persons equally. True, Mr. President, discrimination in a lot of the areas mentioned is not as prevalent today as it was before. But having to bring this piece of legislation, sir, it is an admission that there is still a toxic culture in a few workplaces in Barbados. Mr. President, what amazes me is the fact that sometimes in England, we know that in England and in Canada and in the United States of America as well, that there are persons drawn from every continent, persons drawn from every religion, persons drawn from every corner of the world, persons with conflicting cultures working together at the same hospital, working together in the same stores, working together in the same hotels. And sir, there are one happy family working together. But right here, sir, in little Barbados, you have a workforce of 6, just half a dozen. And people from the same background, people, sir, who are related to each other, people who look like one another, and still they will find it fit to discriminate against each other. Mr. President, there were obvious examples of work-related discrimination which we had in Barbados for many years. And sir, nobody said anything about them. And I wonder why we didn't say anything about them. You know why, Mr. President? We didn't speak up because we were convinced that there was nothing wrong with such discrimination at that time, we thought that what was being done was extremely appropriate. You know, sir, the most classic example I could find was height, believe it or not, in the police force. Height in the police force. Mr. President, let me tell you something. When I left sixth form at school, I was perhaps this country's best 400-meter runner. The only person who could match me was a fellow called Casper Springer, a policeman. You remember him? Casper Springer. And I was also a good cricketer. And I wanted to join the police force because police at that time had perhaps the best athletic program going, and you could play cricket for police and so on. And one of my buddies wanted to join the police force too, but he only reached me to my waist. And they would accept me because it was just about 6 foot flat. And he was about 5'6" or something of the sort. And he couldn't join because he was too short. He was perhaps brighter than I was, but he was too short. He could run nearly as fast as I could too, but he was too short. The only thing that disqualified him from joining the police force was the fact that he was too short. Sir, it is not to say that I was ignorant of the fact as to why it was thought that you had to be a big, tough-looking person to be a policeman. Of course, the thinking at the time was that if a thief or criminal saw someone of this stature coming, he will prefer to run. If he sees someone of the height of my friend, he would say, "What is sending you for?" Because you could see the reasoning. But I could also give you another example of what I know happened. Sir, yeah, you need some brain nowadays. Sir, I saw my father and another gentleman virtually came to fisticuffs to fight on the sand a Sunday. My father was tall, just as I am, and this fellow was short. His name was Baddup, that was his nickname. And they challenged each other because Baddup wanted to prove that a short, strong man could beat a tall, strong man any day. And Baddup was really and truly a very, very tough fellow. They didn't actually clinch. But the point is that they were facing each other, and all that Baddup was saying, in other words, that you don't need height to be strong. Mr. President, a man who is tall is not necessarily a strong man. Mr. President, it should not matter if you are tall or short to join our police force. That, to me, was the first time that discrimination came home in that, because me and my friend together wanted to join the force and he couldn't join it. Couldn't join it. Thankfully, sir, that particular rule doesn't apply today. Does not apply today, but it applied then. And indeed, it was discrimination. Mr. President, another form of discrimination which we had for years, and this is one that again touched me very, very personally. And it was because I had a friend. She was to me like a second mother. A female teacher when I first started to teach at school in St. Philip, Princess Margaret. And she would sometimes talk to me and cry. And she would be crying and telling me how she was so sorry that she treated me like her son and called me her son. because she was telling me she was so sorry that she did not have a child of her own. And she explained to me that when she was teaching and she had a child born out of wedlock, she could not continue teaching. She would have had to leave. She couldn't even join the public service after that. Such was the discrimination against her. And she would sit down and cry with the tears running down her eyes. And sir, her name was Miss Light. I'll call it Miss Light, Matrid Light. And sir, she told me about two of her friends, sir, who tried to commit suicide. One of them died, sir, for the same reason. The same reason. That is what discrimination did to them. If you had a child born out of wedlock, sir, you couldn't continue to teach. You couldn't work in the public service. And these are some of the things we're trying to put an end to now. Up to the 60s, Mr. President is telling me, that was still the rule. Because you see, sir, that was a time when moral values formed a significant part of our general orders. Moral values. We looked at the morality of it. And once the morality was there, they didn't care anything about any other socio problem which you may have. And the rule was not there, sir, to emphasize any discriminatory practice or anything, or discriminatory point. It was there for a moral purpose. A moral purpose. And this was at a time too, sir, when an illegitimate child, when illegitimate children, sir, were outlawed. You can imagine that people that born out of wedlock. My father and mother had 5 children, sir. 2 before marriage, 3 after. I was one of the first 2. Same mother, same father. But I would have been an outlawed child. I would have been. This is what discrimination has done to us, sir. This is what discrimination has done to us. You know how often my mother and father would tell me, change my name from Greenidge to Clark, just to let other people believe that we were all born after marriage. I said, no. No. Once I had enough here to realize it, I said, no. I was an outlawed child. Mr. President, today, if we, well, I could go, the other part of Miss Light's story, the same Miss Light, you know, sir, she's home a day in the evening, and she's attacked home, left laying in blood in her yard, robbed, on the point of death. The gardener came in and found her. And when I heard that, I cried. I cried. Because I remember what she used to say, if only I had a child. And I believe if she had a child, that same attack would not have taken place. And it hurt me, all because of discrimination. But sir, let me go a little further. Because in terms of religion, sir, in terms of religion, there are those who today still see every Rasta man as a threat, every dreadlock man as a threat. Those who today, sir, see, perhaps not here so much, but every Muslim as a threat. I recall, sir, I used to have responsibility for the child care board. And I can tell you, sir, I know of a gentleman, you know him well too, sir. I know of a gentleman who studied social work. He had locks. And he worked at the child care board, applied for and he got the job there. And Then he walked into the office. He still had his locks. He had his locks. He could do the job. And you know, the people around him, including some of the people at the tippy top of the board, they didn't want him. They didn't want him. All because of racial, of profiling. They didn't think that a child care officer who had to make contact with children at the child care board had any right wearing locks. Today, sir, that same gentleman holds one of the loftiest positions in this country. As I said, sir, you know him well, and I will not elaborate on that point anymore. Today, sir, many people with dreadlocks are not even Rastafarian in the true sense of the word. Indeed, sir, I know of a doctor, I know of other lawyers, I know of lawyers now who wear locks. I don't know if for style or for fashion or what, but they're not Rastafarian in the true sense of the word. And even with all of that, sir, there are those who may still believe that if you have a certain hairstyle, you shouldn't work at all in this country. You remember there was a young lady who had to haul a hotel into our law courts, all because of her hairstyle, because she did not fit the profile that the hotel wanted for their guests. So much discrimination, so much of it, sir. I recall too, sir, when I was Minister of Education, that a particular head teacher insisted that a certain teacher with dreadlocks was not welcome at that school. Teacher was laying down the rule, the head teacher. Not the ministry, the teacher. But, sir, even though the ministry had sent the teacher there at that school to work, you know, sir, that teacher made it easy for everybody. The teacher cut his locks off. Made it easy for everybody. Mr. President, only 2 days ago, I was reading in our local newspaper an article, and the headline shocked me. It surprised me. The headline said, Holness, that's the Jamaican Prime Minister, worried about girl barred from school over dreadlocks. And when I saw the headline, I said, that has to be a private school. It has to be a private school, because that couldn't happen at a public school in Jamaica. It has to be a private school. It was clearly a school. It was clearly a school, you know, that wanted a particular image, wanted a particular profile. And the Jamaican Prime Minister said, and I wrote his exact words down, our children must not be discriminated against, nor deprived of their right to an education because of socio-economic issues, such as inability to afford the school fees, or of socio-cultural issues, such as their hairstyles. And that only shows you, sir, the grief that, yeah, it is a life still, the grief that some people have to undergo, and to think that that type of thinking is still alive in a place like Jamaica. It happens here too, but it shocked me that it was happening in the land of wood and water. I was reading, sir, an English case. It's a case, Mr. President, in which 2 Muslims and an Englishman applied for the same job at a particular company in England. The Englishman got the job. Now, the 2 Muslims were confident of themselves. The 2 Muslims knew that they had done excellent interviews. And so the Muslim said, one of us at least. One of us at least. And sir, they sued for discrimination. And during the case, before what could be described as the complaints tribunal, the personnel officer for the company gave evidence and admitted that whenever she had a case where a Muslim and an English person did an interview and they were close to each other, like a tie, like good interview, that she gave the English person the job. No, sir, because of that particular statement and nothing else, because of that statement, the company was made to pay few $1,000s to each of the 2 Muslims, because what the tribunal said was that it showed that she had a bias. And it was made clear to that everyone is entitled to an equal opportunity. If she had said that the English person did the best interview, and that is why the person got the job, it would have been different. But once she said, anytime there's this closeness, I am giving it to the English person. The court said, the tribunal said, no, you can't do it that way. Everybody must have an equal opportunity. And sir, so it is extremely interesting for us to see the changes which have occurred, and not only have occurred here in Barbados, but which have occurred worldwide, and how and why these changes to discrimination would have occurred. Sir, only about 3 weeks ago, I saw a picture in our newspaper again, I think it was local paper again, with the English Prime Minister and his fiancée and a child. Sir, his child, yeah. This is in England I'm speaking about, Senator Rogers. A most prim, a most prudish, a most upright and puritanical and conservative society. And sir, I don't know if the West Indians changed it, but I know it has changed. I know there was a time that could never have happened. That could never have happened. We're changing. We're getting there. Everybody's getting a chance. But I know that could never have happened a few years ago. So, sir, as I get closer towards the end of the presentation, I can safely say that in places such as the United States and Canada and England, that there are indeed employment discrimination tribunals, which, as I said, they act like a complaint board, and they are kept very, very busy with complaints. We don't have a lot here, but there's a lot of it that goes on in England and Canada and the USA. And sir, I also read recently of a Canadian case Canadian case where this fat, she was fat and short, working at a store, and her co-workers referred to her as Miss Piggy. Miss Piggy. And here again, she was compensated for discrimination. You know, so sometimes persons at your workplace can be extremely insensitive. Extremely insensitive. I had promised you, sir, that I would not be long. And so, as you signaled to me to wrap up, that over the years, sir, we in Barbados have been systematically pushing down some of those very, very ugly practices and obstacles from our employment landscape. And this particular piece of legislation, Mr. President, indicates that government will do everything which is required to remove the remaining pockets of discrimination at the workplace. We have to do this, sir. We really and truly, we have to do it if we want to be counted among the progressive nations of this world. So once again, Mr. President, I fully support the Employment Prevention of Discrimination Bill. I'm obliged to you, sir.
And the last of our speakers is Senator Dr. Rogers.
Thank you very much, Mr. President. And I will be very, very short. Much shorter than the short speech given by Senator Dr. Holder. It seems to be, sir, a trait of human nature to compare ourselves with others, and sometimes that can lead us to believe that we're better than and create levels of discrimination. It is a trait of human existence. And I dare say it is also there in the very text that most of us within this country follow as our canon and our religious guide. You would have heard Senator Dr. Holder given an instance. It was the instance of Samuel's selection of David as king of Israel, where he was looking for a particular stature, a particular look of a person whom he deemed would be fit to be king. Indeed, the one before was chosen because he was taller than all the other men in his tribe. In the Old Testament, there's a concept that God is linked to perfection. And so even within the laws of the Old Testament, there is what we now refer to as discrimination against persons with disabilities and any impediment. It is a sign that something must have gone wrong. It is there also in the New Testament where Jesus' disciples ask him, who has sinned, this man or his parents, that he was born blind? Because there was always the perception that if something is wrong with you, it means that you cannot be that close to God. In our context, as I said, we are a very religious community here, and strange enough, the Old Testament still holds a lot of sway in our society. And that, coupled with our history of slavery, gives us two avenues by which discrimination takes place, still in this country. We just celebrated Emancipation Day a few days ago, and the mere fact that this bill is turning up now tells us that there's still a long way towards full emancipation, towards persons experiencing life in the freedom with which God has created them to exist in this world, and the equality that should exist. And in the context of our development of the people out of a slave society, one of the enduring legacies was one utilized very skillfully by the plantocracy to tell some slaves they're better than others. I think that Malcolm X referred to it as the house Negro versus the field Negro. And so you bring some into the house and they start believing that they're better than others. And so you always have someone there who can snitch to tell you what is really going on in the community. And so our society has developed out of that. In addition to that, though they, in theory or on paper, did not see our people to be human, they still found it necessary to have children with our women. And so, in a recent study from 23andMe, it is now suggested that in this part of the world, much of the contribution of the Negro genes came through the woman and not the man, because the females were often exploited by the planter class and their cohorts. And so, out of that, sir, as Senator Springer would have pointed out, we developed this notion of different shades of people. And depending on what shade you had could determine where you fit in and how you are treated within your society. I, for a long time, have discarded all of those things, and I've said it openly, and I'll say it openly here. There was a time in my church where baptisms were done separately, those for the legitimate children, and those for the illegitimate children. I've said that far long expunged from our vocabulary in our church, where I'm concerned, will be the term illegitimate. No child will be deemed to be illegitimate to me. In fact, in this region, I believe that every child is a special gift from God, given our experiences. The mere fact that we've gotten this far, the mere fact that we've survived the transatlantic journey that not many should have survived, and over 300 years of slavery that was harrowing. Every child born in this region is precious and a gift from God. I've prefaced it that way to make the point that the mere fact that we are still discussing discrimination in the workplace bill means that some of these things have almost become psychic aberrations to us, to the point where they're entrenched in our thought processes and the way we treat each other. I am happy to see that we're actually dealing with issues such as disability and the treatment of persons in the workplace who may be differently abled. I like that term because they are able, but maybe just be differently able. In fact, in this very chamber, sir, the seat you now occupy was once occupied by one whom we refer to as differently able, and we give thanks to God for the foresight and the maturity of Barbados to actually recognize the gifts of persons who are differently able. But there's still a long way to go, because just during the COVID period, there was an ad where some people from the differently able community were talking, and one of them said, "Why is it that when persons see me, they think I need help crossing the street? I do not need help. I just need an opportunity." And I hope that our employers understand this, that there are people out there with great intellect and great skills who deserve their place in the workplace and who deserve to be treated equally in the workplace. That may also mean that we have to be more sensitive as a people, because discrimination in the workplace may not simply be what we say to others or not say to others. It can come simply in, we have a building that is not even retrofitted for the differently able, that we haven't even given them thought that such people will come and would be here, you know. In as much as they work amongst us, we haven't given thought to how they can access our buildings freely and in the best way possible. So these are also signs of latent discrimination, simply because we haven't thought it through. Lots of the things that I would have mentioned have been mentioned before, sir, so I'll just skim over them. Trade union affiliation, I cannot speak to that as well as my colleague, Senator Moore, but I would like to see the day when every worker in Barbados can feel free to be linked to a trade union without fear of discrimination in his or her workplace. In fact, just a few days ago on the radio, we were talking, and someone called in from the gas attendants group who work at the gas stations. Very perilous job, but they were saying how difficult it is to be unionized, because as soon as you mention union, your little pick is gone. And that cannot be happening in the 21st century Barbados. You know, if we're going to be serious about discrimination in the workplace, all people should have the right to representation. And any employer who dare challenges that, there ought to be something that we can do legally to deal with them. But people should have the right to a recourse through trade unions. Strange enough, 1937 gave rise to most of our trade unions here. And still, 83 years later, people still cannot join a trade union without being discriminated against. Of course, I'll probably be expected to speak about religion, but the reality is that I believe that all people should be able to practice their religion freely and should have the right to do so. And Rastafarianism is one of the only movements or religions emerging from our region should be cherished by us. And therefore, I would like to see the time when Rastafarians are not discriminated against because of their hairstyles or their style of worship or anything for that matter. But what I really want to zero in on, sir, are two things. One that Senator Holder spoke of rather passionately, the old school tie in Barbados, and what it does to the psyche of people, especially our children. I did not sit 11 plus in Barbados, so I do not know the pressures of that. Where I went to school, I did my exam in grade 6 and I went to grade 7. It was simple as that. But I have a daughter who sat 11 plus, sir, and I see the pressure that these little ones are under every year to produce a mark so that they can get to a particular school. Because it seems that in Barbados, one day in a child's life at 11 can determine the rest of his or her life and how he or she is treated in this society, no matter what they achieve after that, no matter what level they rise to after that. One day in their life can determine how they're treated and how they're perceived and their intellectual capacity in Barbados, which ought not be. And so I would like to join with Senator Dr. Holder to appeal to us all, and I say us because sometimes I joke and talk about where I went to school. I've done it in here as well. I also joke about where Senator Moore went to school. Sorry, but you know, but these are a part of the psyche. But I would like us to get past that because it affects people's mobility in their workplace as well. And Senator Holder would have mentioned that eulogy. I cringed when I heard it at the point in time, and I'm sure that most persons there did, because it did not speak well of the dead as we expect eulogies to. I'll leave it there. But I want to zero in on gender, sir. There are several things linked to this legislation. And one of them, I haven't done a study, but one of them may well be the birth rate in Barbados. I remember a few years ago, I got a call from a young lady, and she was crying. I asked her, what's wrong? She said, I'm pregnant. I said, so what is there to cry for? Because I know she's married, she had 2 children. Isn't it for your husband? She said, yes. I said, so why are you crying? She said, because where I am in my job, I cannot get pregnant now. And there are many workplaces in this country where women feel they cannot get pregnant because it prevents them from moving up the ladder. I am happy to see Section 21 here, but those are just words. What we need to change is an attitude in our country where it comes to how our women are treated in the workplace. You know, I've heard of employers who said, I will not hire women between a particular age. Because if they get pregnant, that's a loss of time for me. It's too much trouble. And we're talking about the Barbadian family here. We're talking about the fabric of our society. So when I heard you, Senator Greenidge, speak about Miss Knight, there are lots of Miss Knights out there still. There are lots of Miss Knights out there who believe that I cannot get pregnant or else I cannot move up in my job. And there has to be something done about that in this country. Because what we're really doing is destroying the development of the Barbadian family. Destroying the desire of our women to procreate. Desire of our women to have a family. And many of them, sir, I believe end up like that lady I would have spoken to, or Miss Knight, having to make decisions contrary to their own faith, their own philosophy, just to make sure that they can hold on to a job in this country. And that is not right. And I think that it is something that we ought to keep pushing and addressing so that persons will understand that it is a divine responsibility to have a child. And when a woman is granted the opportunity of that gift, she should be encouraged as much as possible to exercise her fecundity. I know it would have been mentioned before, sir, under Section 2, the interpretation, domestic partnership. My challenge with it is that it seems to resemble that calypso by the mighty Spoiler, when the judge tried himself and then charged himself a contempt of court. It's a rather circular definition in my own layman's terms. A domestic partner shall be construed accordingly, domestic partner. It used to tell us you cannot use the same word to define itself. And that seems to be what this legislation is doing. But I want to take it a little further. So I want to know, I would encourage us to stop using all these different terminologies. In one bill, the remote employment bill, we had the term partner. And now we have a domestic partner. And in the Family Law Act, Caption 214, we have a union other than marriage. And that union other than marriage, based on this definition now, falls under the notion of domestic partner. I would have thought that we could use union other than marriage, since it is already linked to marriage in other pieces of legislation, to pinpoint those persons who have cohabited for 5 years. If we are trying, as some senators have suggested, to be a catch-all to incorporate something that is not yet defined in our legislation. I would tell us that that is also a form of discrimination, because you're really taking a group of people whom you want to involve or may want to involve, but you do not want to talk about them, and so you're actually discriminating against them by not properly defining who they are. I will not go into the depth in which Senator Dr. Holder went regarding people who are different or we consider of a different sexual orientation. I believe that is a debate that will come in time, and I will give my theological perspective as well as my scientific perspective on that. But what I would encourage us to do is not to create so many definitions in our legislation, some which are not clearly defined. If we want to incorporate any group that our legislation does not yet recognize, I think we should bring the relevant legislation here, or as Senator Moore said, have a referendum, and let us do it properly so that we do not have all these pieces of different definitions floating around. I firmly believe, and I'm a liberal, quite unlike Senator Holder, that a government has the right to ensure that every person living in its jurisdiction can live his or her life in the freedom with which God has created him or her, or they perceive that God has created him or her. And that is not something we should skirt around. Let's just deal with it, you know, rather than bringing different definitions which are not very clear, because it must be hurtful to people. It must be hurtful to people. We already have a world where there are stateless people. Let us not create shadows of our citizens. If there are people out there who are different, and we want to incorporate them in a meaningful way in our society, let us bring it to the fore. You know, yes, there'll be some for and there'll be some against, but there are human beings who deserve a right to live in their Father's world. And regardless of our religious perspectives, regardless of our philosophical point of view, they are human beings with blood running through their veins. And they have a right to freedom. They have a right to live. And so with that, sir, I wish to encourage us that while we're creating legislation, let us not create legislation against discrimination that in and of itself discriminates against others. I thank you, sir.
You were the last of our speakers, and so the question is.
Mr. President, thank you very much. I really did enjoy the contributions of all of the honorable members of this chamber. Senator Dr. Springer speaking about fairness, the types of discrimination that he sees locally, and inviting us all to look at the bigger picture of how we manage diversity in the workplace. Senator Moore, who reminded us that a long time ago we ratified conventions that really and truly we are now only 40-something years later getting around to, but more importantly, that even doing so now that there remain gaps in terms of how labor and workers' rights, and the fact that there's a whole lot more work to do to enable access to these very rights, and that we need to understand that enforcement matters. And Senator Dr. Holder, who spoke to us about the fact that she agrees that anti-discrimination is good for us, but we have to understand that there are certain costs to discrimination, that there are certain cultural realities that we have to pay attention to, and the fact that her perspective, that as we look at diversity in the workplace, that we need to have some limitations on those that could in fact be tempered by science and what she calls the absolute truth. Senator Greenidge certainly shared with us the way we were, sharing stories of the kinds of discrimination that was considered appropriate at the time, and the fact that over the years we have come to change these types of discriminatory acts and the discriminatory thinking that went with those acts in a way that he believes has served us well as we go forward. And finally, Senator Rogers speaking to us about the fact that it is not just about having the anti-discrimination legislation, but that there needs to be some sensitivity. We need to give some thought to the needs of people that we are seeking to include. And he certainly spoke about the fact that there are certain ills that are still prevalent, whether it relates to the old school tie or it relates to discriminating against women who feel themselves threatened, their jobs threatened, and have that insecurity. There was much other significant contributions, but I just wanted to capture those, Mr. President, because I think they're significant parts of the record of this particular debate. And I am happy to say that everyone has expressed their support for this bill at this stage. And so with these few words, I beg to move that this bill be now read a second time.
The question is that the bill under discussion, the Employment Prevention of Discrimination Bill 2020, be now read a second time. All honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Mr. President, I beg to move that Your Honor do now leave the chair and the Senate resolve itself into committee for further consideration of this bill.
The question is that I do now leave the chair and the Senate resolve itself into a committee of the whole Senate for the further consideration of this bill in committee. All honourable members in favour, please say aye.
Aye.
Those against, please say no. We think the ayes have it, and we are now in committee.
And it is now in committee.
Part 1, clauses 1 and 2.
Mr. Chairman, I beg to move that Part 1, clauses 1 and 2 stand part.
The question is that Part 1, clauses 1 and 2 stand part. Honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Part 2, clauses 3 to 7.
Mr. Chairman, I beg to move that Part 2, clauses 3 to 7 stand part.
The question is that Part 2, clauses 3 to 7 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Part 3, clauses 8 to 22.
Mr. Chairman, I beg to move that Part 3, clauses 8 to 22, stand part.
The question is that Part 3, clauses 8 to 22, stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Part 4, clauses 23 to 33.
Mr. Chairman, I beg to move that Part 4, clauses 23 to 33, stand part.
The question is that Part 4, clauses 23 to 33, stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Part 5, clauses 34 to 40.
Mr. Chairman, I beg to move that Part 5, clauses 34 to 40, stand part.
The question is that Part 5, clauses 34 to 40, stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
First schedule.
Mr. Chairman, I beg to move that the first schedule be the first schedule to the bill.
The question is that the first schedule be the first schedule to the bill. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Second schedule.
Mr. Chairman, I beg to move that the second schedule be the second schedule to the bill.
The question is that the second schedule be the second schedule to the bill. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Report.
Mr. Chairman, I beg to move that you do now report to His Honour the President the passing of one bill in committee.
The question is that I do now report to His Honour the President the passing of one bill in committee. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move that this bill now be read a third time.
Question is that the bill under consideration be now read a third time. All honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Employment Prevention of Discrimination Act 2020.
Question is that the bill under consideration do now pass and be so cited. That is to say, as the Employment Prevention of Discrimination Act 2020. All honourable members in favour, please say aye.
Aye.
Those against, please say no. We think the ayes have it. And the bill has now been passed and will be so cited.
Order number 5, sir. In the name of the Honourable Leader of the Senate, to move the passing of a resolution to approve in accordance with Section 5 of the Crown Lands Vesting and Disposal Act, Chapter 225, the lease to the Queen Elizabeth Hospital Board of 2 parcels of land, the property of the Crown, situate at Martindale's Road in the parish of St. Michael in this island, for the purpose of the provision of health services and to facilitate development program.
Mr. President, this resolution seeks merely to lease 2 parcels of land, 2 parcels of Crown land situated in Martindale's Road, St. Michael, to the board of the QEH. The lands to be leased are currently occupied by the hospital campus, containing 52,307.3 square meters, and the neighboring Enmore complex. I believe that we all know that the QEH is a board, and it was drawn to the attention of the CEO in 2012 by the auditors, due to their attention, the need to have a legal instrument that would permit the QEH the right to occupy and use and continue to maintain and use the facilities that they occupy. It is expected that the lease will be for a period of 50 years at the concessionary rent of $12,000 per annum. these few remarks, I beg to move that this resolution do now pass.
We are item number 5 on the public business. And the question is that the resolution under consideration do not pass. All honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it. And the resolution has been passed.
Order number 7, sir. In the name of the Honourable Leader of the Senate, to move the passing of a resolution to approve, in accordance with Section 5 of the Land Acquisition Act, Chapter 228, the compulsory acquisition by the Crown of the parcel of land situate at Friendship in the parish of St. Michael in this island for the public purpose, namely the development of a national botanical garden.
Mr. President, this matter relates to the land for the National Botanical Gardens, a project started in 2001 by the Barbados Labour Party, which has been in abeyance for some time. It was in our manifesto in 2018, and this resolution before the Senate seeks the approval for the compulsory acquisition of 13 parcels of lands at Friendship St. Michael, comprising a total of some 18.4 acres for the continued development of the said National Botanical Gardens. I should just mention by way of information, so far there's a phase 1 and a phase 2 in terms of the land area available for this National Botanical Gardens. In phase 1, the total in phase 1, with the addition of this 18.4 acres will be 426.3 acres, and in phase 2 will be 165 acres, which popularly known as the prison farmlands, making for a total, I believe, of 500 acres allocated to this botanical gardens. And therefore, I am not going to go into the importance of botanical gardens at this time, but I want to say that I think we all know and we look forward to the finalization of the project. And I beg to move that this resolution do not pass.
The question is that the resolution to acquire the land under consideration by way of compulsory acquisition do now pass. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it, and the resolution has been passed.
Order number 8, sir. In the name of the Honourable Leader of the Senate, to move the passing of a resolution to approve, in accordance with Section 5 of the Land Acquisition Act, Chapter 228, the compulsory acquisition by the Crown of the parcel of land situate at Lot 1, Bush Hall Yard Gap, in the parish of St. Michael in this island, for the public purpose of youth participation in community improvement projects known as the Building Blocks Project.
This resolution seeks approval for the compulsory acquisition of land containing 358.2 square meters at Bush Hall Yard Gap, St. Michael, for the public purpose of construction of key kiosks to foster greater youth participation in community improvement projects under the Building Blocks Project. And in addition to the kiosks, it works on persons in blocks. The location on that piece of land is a large tamarind tree, and it is called a tamarind tree block because youth gather under there, and there's a block there. And the project, but not only in terms of kiosks that they can sell, but also it deals in terms of training them in entrepreneurship and small business management, in life skills training, in terms of the kiosks, and helping them to do other infrastructural works and beautification of selected areas. All in all, it is meant to get persons off the block through giving them skills, teaching them to be entrepreneurs, etc. And I beg to move that this resolution do not pass.
We are item number 8 on the public business. And the question is that the resolution to approve the land at Bush Hall, just described by the Honourable Leader of the House, by way of compulsory acquisition, do now pass. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it, and the resolution has been passed.
Order number 6, sir. In the name of the Honourable Leader of the Senate, to move the passing of a resolution to approve in accordance with Section 5 of the Land Acquisition Act, Chapter 228, the compulsory acquisition by the Crown of the parcel of land together with the building thereon, the property of Valerie Angelique Hamlin, situate at Belle Plain in the parish of St. Andrew in this island for the public purposes of establishing a site of historic and heritage interest.
Mr. President, this resolution seeks approval of land at Belle Plain, St. Andrew, and this site was the residence of Dame Edna Ermintrude Ermeyborn, who was, as we all know, was a trailblazer in politics. And I am obviously not going to try to steal the thunder of any honorable other members of the Senate, especially at this time of the evening. Suffice it to say that she was the first female elected to the House of Assembly here, the first election on the universal adult suffrage. She won with 1,372 votes, and she remained for 10 years in Parliament. In spite of the political environment at the time, she obviously was a very courageous woman who offered her services at that time and obviously helped to change the traditional system and inspired a slew of female politicians in Barbados, I believe. And I see we see some new ones coming on the fore. In 1996, the highway was aptly named East Coast Highway, the Ermeyborn Highway. And obviously she's gone down through the annals. In 1995, she was awarded the nation's highest national award, the Dame of St. Andrew. There is planned now with the acquisition of this property, the Ministry of Creative Economy and Culture will be working in terms of creating a sort of, I don't want to say a museum, but a place of heritage in honor of this remarkable Barbadian female. With these few words, I beg to move that this resolution be now passed.
The question is that item number 6, dealing with the compulsory acquisition of land in St. Andrew for the purposes just indicated, do now pass. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it, and the resolution has been passed.
Which one?
Order number 3, sir. In the name of the Honourable Minister of Tourism and International Business, to move. So we all got it. Sorry, sir. The Honourable Minister of Tourism and International Business. Transport. Sorry. No, let me call it back for anything. To move the second reading of the Representation of the People Amendment Bill 2020.
Thank you, Mr. President. The bill, I rise to introduce a bill, Representation of the People Bill. This is a bill which is to treat to the functioning effectively of the Electoral and Boundaries Commission, Mr. President. As you know, we are living in a digital age, and what the bill attempts to do is to treat to the question of publication of the list of register of electors, as well as changes to the list of electors, and to enable persons to be added or removed from the list of electors using technological means. There are a number of changes that are being proposed, amendments that are being made to the bill, and they follow in the following area. Clause 1, which obviously speaks to the amendment of the Act, Cap 12. Clause 2, which treats the insertion of single language which deals with electronic technology, and that is replicated through clauses 3, 4 through 8. And therefore, Mr. President, this bill is commended to the House for the purpose of allowing persons to, in the first instance, include the use of technology in the electoral process, allow for the distribution of essential information through electronic technology, and also, finally, Mr. President, to allow for the publication of the register to be effected through this legislation. And with this, I ask that this bill be read a second time, Mr. President.
That the bill under consideration be now read a second time. All honourable members in favour, please say aye. Those against, please say no. Methink the ayes have it. The bill is now being read a second time.
Mr. President, I ask that you do not leave the chair and this honourable place dissolve itself into committee.
Question is that I do now leave the chair and the Senate resolve itself into the committee of the whole Senate for the further consideration of this bill in detail. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it, and we are now in committee.
The Senate is now in committee.
Clause 1.
Mr. Deputy President, I beg to move that Clause 1 do stand part.
The question is that Clause 1 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 2.
I beg to move that Clause 2 stand part.
The question is that Clause 2 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 3.
Mr. Deputy President, I beg to move that Clause 3 stand part.
The question is that Clause 3 stand part. Honourable senators in favour, please say aye. Those against, no. Methinks the ayes have it.
Clause 4.
I beg to move that Clause 4 stand part.
Question is that Clause 4 stand part. Honourable senators in favour, please say aye. Those against, no. Methinks the ayes have it.
Clause 5.
I beg to move that Clause 5 do stand part.
The question is that Clause 5 stand part. Honourable senators in favour, please say aye. Those against, no. Methinks the ayes have it.
Clause 6.
I beg to move, Mr. Deputy President, that Clause 6 stand part.
The question is that Clause 6 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 7.
I beg to move that Clause 7 stand part.
Question is that Clause 7 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 8.
I beg to move that Clause 8 stand part.
The question is that Clause 8 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Deputy President, I ask that you report to His Honour the Chair that there has been one bill passed in committee.
The question is that I do now report to His Honour the President the passing of one bill in committee. Honourable senators in favour, please say aye. Those against, no. Methinks the ayes have it.
The chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I ask to move that this bill be read a third time.
Question is that the bill under consideration be now read a third time. All honourable members in favour, please say aye. Those against, please say no. Methink the ayes have it.
I beg to move that the bill do now pass and be cited as the Representation of the People Act, Cap 12, 2020.
Question is that the bill under consideration do now pass and be so cited. All honourable senators in favour, please say aye.
Yeah.
Those against, please say no. Me think the ayes have it. And the bill is now being passed and will be cited as, which one is it? Pardon? Yes, sir. It will be so cited. This is number one. This is what number is. If it-
Order number 10, sir.
10.
In the name of Senator the Honourable K. McConney, to move the second reading. Yeah, sorry. The Honourable Minister of Tourism and International Transport, to move the second reading of the Resolution Life Assurance Company Limited Transfer of Bonds Bill 2020. Yeah.
Mr. President, this is a bill that is meant to effect new legislation to give rise to the creation of bonds for the payment of the funds that were due to those persons who were claimants under the Resolution Life Company. Mr. President, you are aware that this is a matter which has been treated in this place on more than one occasion. The issue that is before us now is for the exchange of a total of 382 million Series G 50-year restructured bonds for the Resolution Life Assurance Company, and they will be restructured under the Barbados Debt Restructuring Program as follows: a cash amount of $86.87 million, Series B bonds accounting for 15 years, amounting to totaling $166 million, and a new series of Series I bonds with an interest rate of 0.25%, totaling $149.74 million. This is the matter before this honorable chamber, and it will enable the payment of these funds to the individual policyholders of the company. With these few words, Mr. President, I do rest. I beg to move that this bill be read a second time.
Question is that the bill under consideration be now read a second
I
time.
just ran through that.
All honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Mr. President, I ask that Your Honor do now leave the chair and this bill be considered in committee. The Senate dissolves itself into committee of the whole.
Question is that I do now leave the chair as the Senate resolve itself into a committee of the whole Senate for the further consideration of this bill in committee. All honourable members in favour, please say aye. Those against, please say no. We think the ayes have it, and we are now in committee.
The Senate is now in committee.
Clause 1.
Mr. Chair, I do ask that clause 1 stand part.
The question is that clause 1 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 2.
Mr. Chair, I ask that the clause 2 do stand part.
The question is that clause 2 stand part. Honourable senators in favour, please say aye. Those against, no. Methinks the ayes have it.
Clause 3.
Mr. Chair, I ask that the clause 3 do stand part.
The question is that clause 3 stand part. Honourable senators in favour, please say aye. Those against, no. Methinks the ayes have it.
Clause 4.
I beg to move that clause 4 stand part.
The question is that clause 4 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 5.
I beg to move also that clause 5 stand part.
The question is that clause 5 stand part. Honourable senators in favour, please say aye. Those against, no. Methinks the ayes have it.
Clause 6.
I beg to move that clause 6 stand part.
The question is that clause 6 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
schedule.
I beg to move that the schedule be appended as a schedule to the bill.
The question is that the schedule be the schedule to the bill. Honourable senators in favor, please say aye. Those against, no. Methinks the ayes have it.
Mr. Chair, I beg to move that you do not report to His Honor the Chair the passage of one bill in committee.
The question is that I do now report to His Honor the President the passing of one bill in committee. Honourable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move that this bill be read a third time.
Question is that the bill under consideration be now read a third time. All honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Resolution Life Assurance. Limited, this is the title.
Transfer of Bonds Act.
It be cited, Mr. President, as the Resolution Life Assurance Company Limited Transfer of Bonds Act 2020.
Question is that the bill under consideration do now pass and be cited as Resolution Life Assurance Company Limited Transfer of Bonds Act 2020. All honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. And the bill has been passed and will be so cited.
Order number 9, sir. In the name of the Honourable Minister of Innovation, Science and Smart Technology, to move the second reading of the Police Amendment number 2 Bill 2020.
That's not in there, not here though. Oh, yeah. 9.
Mr. President, I'm happy to introduce the Police Amendment number 2 Bill 2020. This is a very straightforward bill, Mr. President. It simply aims to provide for the revision of the entry requirements for persons who enlist in the Royal Barbados Police Force. Mr. President, there was a time, and you would have heard Senator Greenidge refer to it in an earlier debate, where to enter the police force you had to be a particular height. This particular bill would now amend that, where out would be the height and chest measurements requirement, and now that has been replaced with a medical exam and bodily fitness. That's what this bill seeks to do. Secondly, the act as it stands now, the principal act, required that a person who would seek to enter the Royal Barbados Police Force would be less than 19 and no more than 30 years old. This new amendment now, this amendment would ask that they be no less than 19 and no more than 35. So it increases that age by 5 years. Additionally, the act as it now stands speaks to part of that qualification being served 3 years as a special constable. This amendment would reduce that by 1 year, where there's only 2 years required as a special constable. So basically, this amendment seeks to make it easier for persons to be able to meet the qualifying requirements, but yet still be considered fit and suitable and competent so to do. It is with these few words that I beg to move that this bill be read a second time.
The question is that the bill under consideration, item number 9 on the public business, be now read a second time. All honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that you do now leave the chair and the Senate resolve itself into committee for further consideration of
Question
the
is
bill.
that I do now leave the chair and the Senate resolve itself into a committee of the whole Senate for the further consideration of the measure before us in committee. All honourable members in favour, please say aye. Those against, please say no. We think the ayes have it, and we are now in committee.
The Senate is now in committee.
Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
The question is that Clause 1 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that Clause 2 stand part.
The question is that Clause 2 stand part. Honourable senators in favour, please say aye. Those against, no. Methinks the ayes have it.
Mr. Chairman, I beg that you do now report to His Honour the President the passing of one bill in committee.
The question is that I do now report to His Honour the President the passing of one bill in committee. Honourable senators in favour, please say aye. Those against, no. Methinks the ayes have it.
The chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move that the bill now be read a third time.
Question is that the bill under consideration be now read a third time. Honourable members in favour, please say aye. Those against, please say no. Methink the ayes have it.
Mr. President, I beg to move that the police amendment number 2, that this bill do now pass and be cited as Police Amendment number 2 Act 2020.
Question is that the bill now under consideration do now pass and be so cited. Honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. And the bill has been passed and will be so cited.
Mr. President, this brings us to the end of our business for today. It has been a long day. It has been not a happy day, not a glorious day, but certainly a memorable day and indeed a historical day. And I want to thank all honourable members for their participation today. And I want to thank you, sir, and the Deputy President for your guidance and your skills during the course of the day. And with these remarks, I just want to ask that this sitting be adjourned sine die, and just inform honourable members that dinner is served. I thank you.
Before I put the motion for adjournment, please let me indicate that there has been developments earlier today, about which you will hear later, which now compel me to make the statement which I will now do. This is the last session of the Senate before its propagation, and I consider it as the appropriate time to indicate that effective 30th of August, I shall be retiring from the Senate. It has been a great privilege and an immense honor serving as your president. I am satisfied that there is an array of rich and diverse talent in our Senate, and I assure you that I shall continue to follow each and every one of you with much interest. I shall miss you all, and I want to thank the clerk and the entire support staff, all of whom have been immensely helpful and supportive throughout my tour of duty. I want to thank my deputy, Senator Greenidge, for all the props and support he has given me throughout my tour of duty. I shall miss you all, and I wish to thank you and extend to you my very best wishes. Thanks very much.
Mr. President, if I may be allowed to speak on the adjournment, because you caught me in total surprise. I must say on behalf, if I might be allowed to do so, on behalf of all honorable members of this chamber, it must come as a surprise to all of us. And I must say that we will certainly miss your guidance, your wisdom, obviously, your years, your experience, your knowledge gathered over several years in this chamber and the other place, and your ability to reflect soberly on some matters that might be just reconsidered tumultuous from time to time. You obviously were able to bring to bear your vast experience and knowledge, and certainly in dealing with persons. I must attest to your diligence, how you would go through everything in terms of the order paper, the patience you had. When I was very concerned oftentimes that you were not watching the clock, but were patiently listening to what honorable members had to say, even if I see when you thought that they were not really making connections, but a little smirk on your face. And I'm certainly sure that with your experience and all your years, I certainly hope that you will find the time. It is not common for us in Barbados, in terms of politicians, to perhaps allow us to read your vast knowledge, your vast experience, that you will find time to do this. I certainly commend you, and I thank you again for all of your diligent work over the past 2 years and a few weeks. And we will certainly miss you. We will certainly miss you in September. I wish you all the best and all God's blessings in your future and your future endeavors. Thank you.
Mr. President, I want to stand as an independent senator and commend you and thank you for the exceptional way that you led the business in this honorable chamber. This was my first experience, and I think that under your guidance, you made it a very interesting one. Certainly, it has been a learning experience. I want to take this opportunity now, following your announcement, to thank you for your indulgence. I think that when Senator Walcott was speaking, he was making reference to the fact that when I was on the floor, you often forgot the clock. and so I want to take the opportunity to wish you well in all your future endeavors. You said you will be watching those of us that remain in the Senate, and I hope that those who remain, you would not only watch, but also allow the opportunity to benefit further from your vast wisdom. Thank you.
Thank you, Mr. President. I too rise to speak on the adjournment and to echo the sentiments of the other senators that it is a shock to us all, but I want to speak to my personal experience in the last 2 years with you and to say thank you. Thank you for the guidance. A lot of persons may not know about the conversations that we would have had in the corridors, in your office. You obviously being a seasoned politician, being able to offer advice and guidance and direction during the last two years. I really cherish those moments, Mr. Speaker, and I want to say thank you. And to wish you all the best in whatever future endeavors you may pursue. This, yes, is the last session for this Senate At this time, we don't know what the future holds, but if I know anything about you, I'm sure that you will avail yourself to any of us or any of the future senators, for that matter, that may call on you for any advice and so on. So I really want to say thank you. It definitely has been a pleasure. I benefited from you clearly not watching the clock on many occasions. Your indulgences as the president. So I really want to say thank you, Mr. President. It has been a rather enjoyable experience for me at a personal level. So thanks again, and God bless.
Good night, Mr. President. I just rise to thank you for the guidance you've offered during my short stint here. It has really been a pleasure with you, and I don't know if you remember, but many moons ago when I was a young lad, you attended St. Xavier's Church one day, and I had done the reading that day, and you came to me after and said, you know, I think you should become a priest. You may not remember that, but I had given it some thought, so you are responsible, sir, in some way for encouraging. And in coming here in my short year and a half here, you've still been as encouraging as you were then. You know, every now and again you will drop a word, that was a good speech, or, you know, keep up the good work. And I'm sure that many persons here can attest to that. And you'll be sorely missed. I think the serious but still jovial manner in which you carry out your work help us all to feel comfortable in this space, even when there are days like this. And, you know, some tempers may fray here and there. Your calm demeanor has helped to keep things quiet, and I wish you all God's blessing in your retirement, and thank you for all that you've done for us here. Thank you very much.
Just permit me to thank all of you for your very generous remarks. I've enjoyed myself greatly. That's at the bottom and at the center of the whole exercise as far as I was concerned. I was always enjoying myself, listening to your diverse contributions, your different styles, and the richness of intelligence, of knowledge that you all display. So that you've helped me in doing this job to enjoy myself greatly, and that was important for me, and I hope it came true. I shall follow you all, each of you, very closely, and I can assure you that with my health holding up, I will continue to be active in other areas. Thank you very much indeed. And now the Senate will stand adjourned without a day appointed.